Soundtrack.
Hi, my name is Joshua Curtis. I'm an attorney at Beresford Booth, and one of the things that I do here is help clients with their estate planning. The subject of today's webinar is what is the single most important estate planning document that someone could have? And it's sort of a trick question. It's like asking what's the single most important tool in your toolbox, or what's the single most important golf club in your golf club bag. The question is, what do you need it for? Do you need a hammer, or do you need a saw? They're going to be two different tools, both very important for the task, but one's only more important than the other given the task that you're trying to do. So what I've done is I've come up with some scenarios that I often get from people and gone through these, and I'm going to talk about how I would in a meeting with a client, talk about the most important document to fit their particular goal. So I often tell people that a durable power of attorney is going to be one of the most valuable pieces of estate planning that they could do. And the reason is that if someone becomes incapacitated, the durable power of attorney is right there. It allows someone to step in, make decisions, financial decisions, healthcare decisions for them without creating a guardianship and going through all the cost and expense and time of becoming someone's guardian. It allows them to step in either immediately or upon it with a letter that stating from their doctor that they don't have capacity, allows them to step in and do what needs to be done. Now, a lot of people might end up passing away without becoming incapacitated. And so for them, it wasn't the most important document. But for anyone who does become incapacitated, this is a document that's going to help their spouse or their kids handle things that need to be handled and do things in an efficient way and relatively quickly, and just get things done that need to get done. So that's one point for durable power of attorney. All right. Another one that people come in, oftentimes they say they want to avoid a probate. And they've heard about probate, maybe from other states. I know in California, probates can be more expensive and time consuming. And so they may have a negative feelings about the word probate and the process. Maybe they've had to do a probate in some state. Or maybe they own real estate here in Washington and also own real estate in another state, say Oregon. They would have to do a probate in the state where they live, and then also in any other state where they own real estate. So potentially avoiding two probates. So usually the most important document then would be a revocable living trust. There's other ways to avoid probate with certain assets, but the most the easiest way and the most complete and thorough way is to use a revocable living trust. So the trust owns all of the assets, whether it's in Washington or in Oregon or anywhere, and then the control over those assets passes to a successor trustee when the principal passes away. All right, so that's one point for revocable living trust. Another thing that I often hear from clients is that they had to make a decision regarding end-of-life care for a parent. And they didn't like making that decision. They didn't like how it made them feel to have to make that decision. And they want to make sure that their kids don't have to make that same decision for themselves. So in that case, the most important document for them is going to be a healthcare directive. It allows you to instruct your doctor with what care you want to have or not have if you're in a terminal condition or a permanent unconscious condition. So more specifically, it's usually an instruction to remove life-sustaining treatment that's only prolonging the process of your passing. So for them, then that's going to be one of the most important things, at least the thing that brings them in the door that they know that they want. All right, so that's one point for healthcare directive. Next is that someone might want to reduce estate taxes. We have estate tax at the federal level, a relatively high exempt amount, so maybe people don't have to worry about that one. But Washington State also has an estate tax with a much lower exempt amount. So someone might be looking for a way, they realize that they're, let's say with a married couple, they realize their combined assets are going to be over the estate tax exempt amount for Washington. So they want to figure out a way to use the estate tax exemption for both people in the married couple. And they can do that through a will, or a revocable living trust. With either one, you can use the exempt amount from the first spouse to die. Part of the assets of the couple goes into a trust that's for the benefit of the surviving spouse, but ultimately goes to the kids. So you have one gift from the first spouse to die to the kids, one gift from the second spouse to die to the kids, and you get to use both of the both of the exemptions for that. So 1 point for will, 1 point for trust on a tool to reduce estate taxes. I've had clients who have come in and they're not married, and estate planning for unmarried couples is probably more valuable than it is for married couples. There's a lot of defaults in the law that allow spouses to make certain decisions or spouses to inherit certain assets. Or a community property law state, so there's assets that are treated as owned by both people if they were acquired during the marriage. So for an unmarried person, the first one is having control over healthcare and medical decisions if their partner was to become incapacitated. Oftentimes, I've had folks say, I would not want my family to do it. I wouldn't want his or her family to do it. I want my partner to make those decisions and no one else. And if the default in some cases is going to default to a family member, they want to make sure that they get their estate planning done to make those, to nominate their partner to do those things um, instead of having it default to parents, brothers, sisters, people like that. All right, so that's a durable power of attorney. 1 point for durable power of attorney. All right, I've had people come in and they recently got married, so maybe uh, one of the people buys a house before they get married, and then they get married and they say, I want to add my spouse onto title for the home. So there's a lot of ways you can do that. You could do a quick claim deed from one person to person and spouse to create community property, but that only deals with one asset. You could do a will where you leave everything to your spouse. That's more complete, certainly, than doing a quick claim deed that only deals with one asset. You can create a trust as well to do that, to leave everything either to your spouse or for the benefit of your spouse. But I'm going to give this one the point to the community property agreement. So, a community property agreement automatically vests all assets in the surviving spouse. So, whether it's a community property asset or a separate property asset, it just, when one person dies, 100% is vested in the other person. So, it transfers real estate, bank accounts, any types of accounts, as long as the assets are in Washington. This is a creation of Washington state law, so it wouldn't transfer assets like my hypothetical home in Oregon. So I'm going to give 1 point to community property agreement and a half a point to will and a half a point to trust. All right, another thing that often brings people in and is a motivation for wanting to do estate planning is that they want to name guardian for their children. So sometimes I'll ask a couple, why now? Why have you decided to do estate planning now? And they might say, well, we're going on vacation for the first time without our kids. In fact, that was when my wife and I did our estate planning, was when we went to a friend's graduation out of state, and we didn't take the kids with us. And so that's what finally prompted us to get ours done. So usually you would name your choice, first choice, second choice, whatever third choice for guardian in a will. You're expressing to a court in the future who you would want to be guardian of your kids, who you think is in the best interest of your kids, but you're also communicating to your family. Here's who I want to petition the court to become guardian, and to avoid everybody feeling like it's their responsibility or they have a duty or they want to do it and someone else also wants to do it. To the degree that estate planning provides some just instructions about what you want, that's oftentimes valuable in for family members to figure out if they have a duty to do something, if they should be advocating to do that thing, or if they can sit back and let someone else do it because that's what you prefer. So so we're going to give 1 point to will there. All right, these next two sort of are similar to each other and similar to the naming guardian issue. In estate planning, you can't leave assets of any real value to minors. And oftentimes you might not want to leave assets to adult children who are, let's say, 18, 19, 20 years old. So you'd want to have those assets held in trust. So with minors under 18, you have to have it held in trust. With people who are 18, 19, 20, to however old someone might want to have this extra step, you'd create a trust, you'd name the trustee, and then the trustee would have authority to hold that money, make distributions, eventually distribute everything and close the trust, usually at a particular age of the folks. But, sort of to help them make good decisions about how to spend the money and put the wealth that you have earned into things that help them, maybe education, maybe buying a house, asset that builds wealth, something like that. But using that money in a way that um, hopefully will be the best way for them. So that's going to be 1 point for will, 1 point for trust, because that could be done in either one. With a will, you could have a will that creates a children's trust, um, and with a trust, you could have your trust could create a sub trust that would be a children's trust. So typically, these aren't created while you're alive because you don't know if you're going to have minor kids or kids under 25 years old when you pass away. So usually these are triggered to get created if it's needed. All right, and then the next one is a special needs trust. So you can create a special needs trust for somebody. You can even create a special needs trust for yourself. Much different rules there. But you can create a special needs trust for someone while you are alive. You can fund it while you're alive. Or you can have a will or a trust that creates a special needs trust, puts that person's portion of the inheritance into the special needs trust, and that can happen. That can get created when you pass away. So again, that's going to be 1 point for will, 1 point for trust. All right, the next one is not a document at all. Here we go. We're really breaking the rules. Some of the strategies with estate planning involve things that aren't estate planning documents. So, for example, making some lifetime gifts. If you have a client who is over the Washington state exempt amount, but has some assets that they could give away, and they're close enough to the end of their life that they feel comfortable making those gifts. I mean, that's really the thing is someone shouldn't make gifts early in their life when they might need those assets in their retirement. But I've had clients who have been close enough to the end that they are confident that they can afford to give away hundreds of thousands of dollars to get them out of their taxable estate, so they don't pay Washington state estate tax on it. So that's going to be 1 point for no document. That's just advice that in working with, I've worked with financial planners, worked with the individuals, I've worked with people's kids in trying to figure out that strategy to make some lifetime gifts, reduce the taxable estate, and then avoid some estate taxes. I guess along with that, maybe we'll give 1 point to durable power of attorney as well. In a durable power of attorney, you have the authority to give gifts. And sometimes that authority could be small, like to give gifts under the IRS exclusion, however many thousands of dollars per person per year. But other times the gift giving authority can be, a much larger, broader authority to give gifts, significant gifts, even gifts to themselves and their brothers and sisters, let's say, in order to reduce estate tax liability. So we'll give 1 point to durable power of attorney as well. All right, and then all right. So next one is actually another non-document, and that is to update beneficiaries on financial accounts, life insurance, things like that. There's usually a beneficiary designation, and if someone wants to make sure that those beneficiary designations are consistent with what they're trying to do overall in their estate planning. Oftentimes, a significant portion of someone's estate would be like maybe a 401k or an IRA would have a beneficiary designation, so it wouldn't be flowing through the will or a trust. And so to think about how if this one large asset is being distributed in a particular way, how does that affect what I'm doing over here in these other documents? So it isn't a document in itself, but sometimes people need to update their beneficiary designations, and oftentimes that can be the estate planning that they need to do. I guess a second point for the no document category here is to update life insurance beneficiaries after if someone was divorced. I have seen it where someone had the wills, and some things are often automatic. There's things that can happen automatically. Automatically revoked a durable power of attorney for a spouse or something like that when if there's a divorce. But life insurance beneficiary designations don't change with a divorce. So there's a possibility you could be leaving your life insurance to an ex if you don't get that updated. So it's definitely worth doing. All right. Here's one. Okay, I've done a lot of work in sort of the purchase and sale area. I worked with a lot of buyers and sellers and real estate agents and mortgage brokers and stuff, working on trying to, everyone generally wants to get a transaction done. So, working to solve problems and get a house purchased, sold. And I've had people become incapacitated during that process. And so the only thing that can be done, well, if there's a durable power of attorney, then the durable power of attorney gives someone authority to act on their behalf, and that person can sign the deed and do things that they need to sell a house. But if there isn't a durable power of attorney, then you're scrambling, to get a guardianship with some temporary powers to finish a sale, or you're going to end up breaching the purchase and sale agreement with the buyer. So that is a big point for durable power of attorney. There's some things that the other spouse or the kids maybe could do on their own because they might be on accounts as well. But something like selling a house is going to require each owner signing a deed, and if they don't have authority to sign a deed, then you hope that, or if they don't have the capacity to sign a deed, you hope that there's something that gives someone else authority to sign the deed. All right. Next one is giving a specific gift to a specific person. So there's a few ways that you can do that. You can do it in a will, and you can do it in a trust. You can make a specific gift to a person, a class of people, a charity, something like that, in both a will or a trust. And then similar to that is to give a specific piece of real estate to a specific person. And in that one, the document would be, or could be, a revocable transfer on death deed. So that does exactly what it sounds like it does. You can revoke it up until you pass away. You can sell the house, mortgage the house, grant an easement over property, to your neighbor. Whatever an owner can do, you can do. But when you pass away, it automatically transfers to the people who you've named in that revocable transfer on death deed. So I think that's the only point for revocable transfer on death deed in my list here today. But all right, next is when you have a blended family. A couple might get married later in life. Each one has their own kids. They have a lot of different motivations going on. They want to make sure that their spouse is provided for. They also want to make sure that their kids get, the assets that they brought into the relationship. And the same thing with the spouse. They want to make sure that, their kids get their assets. So that can be done with a revocable living trust, where the surviving spouse can have use of assets from the deceased spouse, but ultimately, they go to the deceased spouse's kids when the surviving spouse passes. So there's ways to provide for the standard of living of the surviving spouse, but also make sure that all of those assets don't go to his or her kids and not back to your own kids. All right, so that's 1 point for trust. All right, out of state real estate, actually specifically out of state rental property. So we talked about using a revocable living trust to avoid a probate in 2 states. Maybe that pencils out. It makes sense. That's a good thing to do. Another way to do it is to put the real estate that you have, especially if it's a rental real estate, this makes a lot of sense to do, even not as an estate planning tool, just as a good liability tool, but put that rental property into an LLC, because then what you own is an LLC. You don't own real estate in Oregon. You own an LLC in Washington that owns real estate in Oregon. So then then you don't have to do a probate in Oregon because of the real estate that's here. So that's going to be the only one for LLCs. It doesn't, I don't think, have any other points here on my list today. All right, I've often had people say, well, I want to make sure my brother and sister don't get anything, right? Okay, so we talk about, do you have, are you married? Do you have kids? We figure out where they want it to go, but sometimes they come in specifically saying where they don't want it to go. So it could be, I don't want it to go to my parents. I don't want it to go to my brothers and sisters. I don't want it to go to my spouse's brothers and sisters. It can also sometimes be one of their own kids. I want it to go to kids A and B and not to kid C. Um, so, wanting to either disinherit somebody or to avoid distribution based on heirs at law. So your heirs at law are your closest living relatives. There's a hierarchy of how that is figured out. But someone's parents or brothers and sisters could easily be their heirs at law if they don't have any spouse or descendants. So sometimes someone wants to say, well, if I don't have any spouse, I don't have any kids, I want my entire estate to go to my favorite charity, my favorite cousin, my favorite nephew, niece, whatever. But if they hadn't done that estate planning, it likely would have gone to their siblings, and maybe that's not what they want to do. So that can be done with a will or with a trust, but having more power on directing where that goes instead of relying on the statute that makes it go to heirs at law, which you don't get to control who your heirs at law are. All right, next one is a life estate. So life estates aren't used very often, but it's a type of estate planning where you can give somebody the ability to use real estate for the rest of their life. They have to pay, if there's a mortgage, they have to pay a mortgage. They have to pay property tax, insurance. They can't let the place go to waste, but they get to use it for the rest of their life, and then that right terminates when they pass away. So that can be done with a deed, deed now to person B, reserving a life estate for person A, let's say, or reserving a life estate for yourself. But usually in estate planning terms, it's that someone wants to create a life estate for someone else. And so that could be done with either a will or a trust. The document could create a transfer where there's a current possessory interest owner, and then a person who would get the all the property rights after that person passes away. All right, so that's one for will and one for trust. All right, here's one, a fun one. I've had clients that are worried about how their kids will spend the money that they're going to inherit, and so they want to put some guides on that, and either put some people in place to help them make better decisions, or just put rules in place that prevent them from doing things that they wouldn't want to do. So let's say somebody has their assets that they've accumulated during their life, and they say that they want their kids to you can use it to buy a home, or you have to save it for retirement. So that you use it for an asset that builds wealth, or save it for retirement. Those are acceptable options for the client. That's what their kids could do. So that has to be done with a trust, with the revocable living trust, because the control over that money, you have to have a trustee who will follow the instructions, and the instructions have to be that here's where you're allowed to use the money, here's what you're not allowed to use the money for, and then ultimately here's what you can do to distribute and close the trust. But it could go decades with the trustee managing those assets for the beneficiaries, and following the rules that a person put in place in their revocable living trust. So that's trust. All right, the next one is The document is a disposition of remains. So it's an instruction. It says, I want my remains to be cremated, buried, composted, um, and then you put that in writing, and you have that as part of your estate planning. The alternative is that if you have a spouse, the spouse gets to make that decision. If you don't, it's a majority of adult children that get to make that decision. And then there's other family members that may be able to if you didn't have adult children. And, you know, some people feel strongly about how their remains should be, um, treated after they're gone. Some people have paid for things. And so we definitely want to make sure that we remind their kids, that something has been paid for so that thing can be used. But the disposition of remains document is one that lets you, say who or say what you want done, and then the goal is to avoid disagreements between people, confusion between people, fights between people. Um, so these examples, these are all things that I have, clients that I've talked to, or situations that I've seen, and really, for a lot of people, the most important document that they're going to do is going to be different. Um, and for a lot of folks, what they think might be the most important document may not be the most important document. I always tell clients if I had a crystal ball, I'd charge a lot more for what I do. But our goal as estate planning attorneys is to do the best that we can to put a plan in place that's flexible for their family situation, life circumstances that might happen, and changes in the law, changes in asset levels, but put something in place that can be a little bit flexible and deal with a variety of different things that they might come up against. So, you know, while it may be impossible to know the single most important estate planning document, maybe the moral of the story is to think about your estate planning, think about what documents may be valuable to you, in what circumstances are possible to happen, and how the estate planning documents can help deal with those circumstances. Um, but do something, because by doing something, you express to your family members what you want so they don't have to wonder. You can make it easier for them to do what you want them to do, or to help you while you're living, or to take care of things when you're gone. But any estate planning will make that process easier on other folks that have to do something for you on your behalf, either your behalf or your estate's behalf. And I often ask people what I mentioned earlier, why they're doing their estate planning, and sometimes they say, I had to do my parents' estate, and either it went well, and I want to make sure that I have things in place for my kids so it goes well for them as well, or they say it went terrible, and they want to make sure that they have in place some documents, some tools to make sure that their kids don't have to struggle through the same things that that they that the other that they had to in the estate they were doing. So I'm going to count these up really quick. Uh, Wills and trusts are definitely going to be our winner here. All right, so trust has 7 votes as the most important document. Wills with 6. Both of those do a lot of things. They communicate a lot of things to people in your life. They communicate, or they allow people to do stuff that's easier to do. Durable power of attorney came in with 5. I probably could have thought of more hypotheticals where a durable power of attorney has been the most important document that someone needs. But ultimately, just remember, it's not a particular document that you need. It's an estate plan that you need. So, thinking through these documents, thinking through assets that aren't going through these documents, like beneficiary designations, and figuring out how to communicate to your family and to your friends and relatives, what you want and how it needs to get done. So, I appreciate your time and listening to me today. Estate planning is fun. It's fun to talk to people, ask the what if questions, and try to drill down into you know trying to make sure that what they want to get done happens. And I enjoy that part of my job. So thanks for taking the time, and thank you. Bye.